Void judgment, sovereignty and living.
World, kings and emperors will soon pass away and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. The Pope, the Vatican, now owns and operates the bankrupt 1871 corporation at 16 Stat 419, as evidenced by the Roman Achaea military staff that's planted on all conquered nations, that's sitting on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man, that are on the wall of each side of the Speaker's podium in the U.S. House of Representatives, which is also why Nancy Pelosi, when she was Speaker of the U.S. House of Representatives, told members of Congress, we can't read this bill until after we pass it, because she was taking instructions from her Vatican handlers, all of which is evidencing the fact that the 1871 corporation at 16 Stat 419, currently operating in the District of Columbia, is a Vatican-dependent city-state, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican City State and criminal matters that talks about concurrent jurisdiction in other states, which means the other papal states, like the District of Columbia and the City of London, United Kingdom Crown. And there's a picture of the Speaker's podium in the U.S. House of Representatives, and there's the two Roman fascias, and there is the Roman Achaea military staff. And this is that apostolic letter. When some matters are prosecuted in other states, the provisions in force in Vatican City State, a concurrent jurisdiction shall apply. Entering into force on September 1, 2013. And the Vatican's Pope Francis came and addressed his owned and operated Congress on 24 September 2015, and the Pope's satanic private bar guild members are assaulting people with their Roman fiction of law, minor estate, sestike use, usufruct, trust, necromancy, with presumptions of jurisdiction, presumptions of the office of trustee because the sestike be usufruct minor estate, and presumption of suretyship.
Why do you think the members of Congress have to be attorneys, lawyers? Right? Aren't they supposed to be voted in by the people? And who the people decides? Not if the bar members. We're allowed to vote for who we want in there, bar or not. This country did not start off with bar members.
I'm entitled to common law, not canon law / Roman law, as described in Article 6, Clause 2 of this Constitution for the United States of America. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties shall be made under authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And also in the Judiciary Act. Saving suitors in all cases the right to a common law remedy, where the common law is competent to give it, shall also have exclusive original jurisdiction, cognizant of all seizures on land and other waters as aforesaid made, and of all suits for penalties and forfeitures incurred under the laws of the United States, 1 Stat 77, Section 9A, and the Judicial Code of 1911. Because law of the land phrase is a convertible phrase with the phrase common law. The principle that no person should be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed on the 19th day of June, 1215. Remember, that's after 2 years after the concessions to the Pope. The Welsh barons rose up in rebellion and stuck a sword to King John's throat and said, "We're not having any Roman law here." No freeman shall be taken or imprisoned or seized or outlawed or exiled or anywise destroyed, nor shall we go upon him nor send upon him but by the lawful judgment of his peers or the law of the land. It has even been said that the principle was known before Magna Carta and that it was originally designed to secure the subject against arbitrary acts of the crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as a part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. And that's Book 16, American Jurisprudence, Constitutional Law, Section 543. And the common...
And right there, okay? So keep that in mind, right? Everybody keeps saying the Constitution is law of the land. Well, it's the law of the land for the government body that takes oaths to uphold the Constitution. But the Constitution does not apply to us, right? And the justice system, where we supposed to get remedy, is in common law. Whether you go to prison or whether you get sued or anything like that, right? It's supposed to be common law, and the common law is the law of the land for the people. The Constitution is law of the land of do not trespass upon the people on the government.
On the law of the land has always been here from before the government was here. The individual may stand upon his constitutional rights, his rights such as existed by the law of the land long antecedent to the organization of the state. That's before, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. And because their Vatican maritime codes only apply on the high sea.
And just in case you didn't catch it, that's Hale versus Hinkle. I keep saying that, Hale versus Hinkle.
And up to the high water mark or the first bridge of any navigable river, and the District of Columbia or any federal enclave is found in Article 1, Section 8, Clauses 17 and 18. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as made by session of particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. And I have been very vociferous about being posterity as found in the preamble and the living man and the living soul in every document filed into this case, evidencing the fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor's prejudgment on behalf of their private bar guild and their Vatican handlers. It's impossible for me to give any of these wrongdoers or bar member handlers or this court any authority over me, and John Marshall, the Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed. Said it's impossible for me to confer sovereignty which will extend over me, and we already read this case, McCullough versus Maryland. I'm exempt from these wrongdoers and their Vatican corporation and their bar member handlers, not because of any formal conception or obsolete. Let's change this.
Wobbly railing at home? Fix it with this.
Not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right is against the authority on which the right depends. And that's Cowan and Cole versus Polyblank. I already read that too. Matter of fact, this other stuff I read too. And fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor absolutely refused to regulate their property, and none of them produced any evidence of a bona fide contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor have ceased to represent the government. An officer who acts in violation of the Constitution ceases to represent the government. Fake magistrate Judge Hal R. Ray and fake Judge Reed O'Connor and their Bill of Attainder and their Bill of Pains and Penalties are unconstitutional acts and a nullity. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It's a legal contemplation as inoperative as though it had never been passed. An unconstitutional law is void and is as no law. An offense created by it is not a crime. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Their so-called court is a kangaroo court. A kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, which the result is a foregone conclusion because of the bias of the court or other tribunal.
And this is why I said it the last couple of times, right? Even the lower courts, if the higher court says we have to do this, but if it's unconstitutional, the lower courts does not have to comply with it. They are led to believe they do, but all courts are supposed to sign an oath of office to uphold the Constitution. And in your states, your state and federal Constitution. So, if the higher courts are acting in dishonor, then it's up to the lower courts going, I don't think so. But, that being said, it don't give them obsolete discretion to ignore the Constitution. And we had to fight it to the Supreme Court to get them to say it is. You see how that's working? Supreme Court says, well, I'm going to violate the Constitution. Here's you for your lower courts. Well, okay. Well, I'm going to extend the violation of unconstitutional deal and create more stuff. And then we had to fight it to go all the way to the Supreme Court. Then the Supreme Court says, well, no, that's unconstitutional. When the Supreme Court turned around and said it was constitutional.
Everything they did is a fraud and a nullity. Once a fraud, always a fraud. Things invalid from the beginning cannot be made valid by subsequent act. These are all maxims of law. A thing void in the beginning does not become valid by lapse of time. Time cannot render valid an act void in its origin. Out of fraud, no action arises. And any act by any government official to conceal a fraud becomes an act of fraud. It's a fraud to conceal a fraud, and fraud is inexcusable and unpardonable. Fraud and deceit should excuse no man, and any fraud amounts to injustice. Fraud and justice never dwell together. What is otherwise good and justice, if sought by force or fraud, becomes bad and unjust. And their bill of pains and penalties, fake judgment, is brutum fulmen. Brutum fulmen is an empty noise, an empty threat, a judgment void upon its face, which is in legal effect no judgment of all, and by which no rights are divested, and from which none can be obtained. And their fake judgment is void and an absolute nullity. A void judgment is one from which inception is a complete nullity and without legal effect. A void judgment is one which has no legal force and effect whatever. It's an absolute nullity. Its invalidity may be asserted at any time by any person whose rights are affected at any time and any place, and it need not be attacked directly, but may be attacked collaterally whenever and wherever it's interposed. A void judgment, insofar as it purports to be a pronouncement of a court, is an absolute nullity. A void order may be attacked directly or collaterally at any time. A void judgment is one which from its inception is and forever continues to be absolutely null and without legal efficacy, ineffectual to bind parties or to support a right, of no legal force and effect whatever, incapable of enforcement in any manner or to any degree. Not every action by any judge is an exercise of a judicial function. It's not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force or effect. And fake Judge Hal R. Ray and fake Judge Reed O'Connor are both personally liable in their private capacity. Judge loses his absolute immunity for damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. Fake Judge Hal R. Ray and fake Judge Reed O'Connor, fake Magistrate Judge Hal R. Ray and fake Judge Reed O'Connor unfiled the 78 criminal complaints that I filed into the case in support of their Federal Bureau of Investigation refusal to investigate the 78 criminal complaints, in support of their targetedjustice.com agenda to refuse to investigate felonies against targeted individuals like me in the hope that I'll exercise my right to resist their unlawful arrest and their unlawful theft of my land with lethal force if necessary, as found in United States versus Schooner Amistad, and so they'll have an excuse to murder me and say they killed another sovereign citizen terrorist for their communist handlers in support of their war crimes agenda to take reprisals against anybody who thinks they have rights for their political beliefs, all of which is in support of their private bar guild and their Vatican handlers who love satanic blood sacrifices to the Roman cult god Baal. Fake Magistrate Judge Hal R. Ray.
Yeah, this thing that they call sovereign citizen, under their definition, the judges got all these paperwork when people stand up on the rights, was they had to come up with something. Well, we can't have these people actually know their rights. Oh, okay, let's call them sovereign citizens. Okay, we'll call them sovereign citizens. Well, what's the definition? Oh, it's people that don't believe in government. In short, right? So therefore, if anybody stands up for their rights, they're going to be automatically called sovereign citizens. So that way, all the dum-dums could be held down and all their prisoners, their subjects, is going to be no wiser and then go after the sovereign citizen because they hear from their attorneys, oh, they're sovereign citizens. And judges say, oh, you're a sovereign citizen. Oh, okay. So the judges are right. Meanwhile, most of the people don't trust government. And yet, what do they believe? They just contradict themselves. So think about it, y'all.
Judge Reed O'Connor intend to be accomplices in conspiracy with the County of Montague thieves and their Federal Bureau of Investigation accomplices to facilitate the theft of my land under color of law and my murder for their private bar guild and their Vatican handlers that love satanic blood sacrifices to their Roman cult god Baal. Fake Magistrate Judge Hal R. Ray and fake Judge Reed O'Connor have demonstrated they intend to conspire with the County of Montague thieves and their Federal Bureau of Investigation accomplices to engage in a seditious conspiracy to overthrow this Constitution for the United States of America for their